So effectively every week the government says these are all the things that American citizens can't do for about the next 20 years.
Hi, I'm Nick Gillespie for Reason TV, and today we're talking with Derek Khanna. He's a lawyer and an intellectual property specialist who has a great paper out from Lincoln Labs called How to Fix Patents. Economic Liberty Requires Patent Reform. Derek, thanks for joining us.
Thanks for having me on.
Okay, talk about a patent. Define it for us. What does it do, and what did the founders who put patent law in the Constitution, or the idea, what did they want out of it?
So a patent is a government-granted monopoly, and it's legally defined as the right to exclude. So the government gives you this monopoly and says only you can do this invention, and no one else can. So effectively every week the government says these are all the things that American citizens can't do for about the next 20 years. And they were really supposed to be kept for inventions, things that required a tremendous amount of research and development to allow you to recoup upon that investment. And also had a second reason, which is they wanted people to come forward and to share their discoveries in the form of a public disclosure so that way others could learn from it, as opposed to keeping it as a trade secret and keeping it internal.
So this is the difference between a trade secret is something like the Coca-Cola formula,
yes,
which is hidden in a vault somewhere in Atlanta, we believe. And a patent, it's like the electric light bulb, the Edison light bulb,
yes,
where you actually write down everything so people can see from it.
Yes.
Yeah. And a patent term lasts for about 20 years. Mm-hmm. So talk about the abuse of the patent process right now. Where is it the most absurd?
So in the founding era, patents were reserved for things that were really novel. There are about 600 of them granted in the first 10 years. It required the Secretary of State to personally sign off. And the reason is because they didn't consider this to be part of the free market. They saw this as an abridgment upon the free market, and you really wanted to be careful about when you actually did this. But today they're being granted across the board, and they're being granted in some cases for technology that's moving so quickly that by the time the patent expires, there's almost no purpose to it anymore.
What's an example of that?
So in 1995, Microsoft got a whole bunch of patents for their upcoming operating system, Windows 95. Well, was there a big party of January this year when you had hundreds of patents expiring and programmers able to create their own versions of Windows 95?
Right, yeah.
It's just an illogical premise in the modern age.
Yeah, and you talk about, one of the examples in the paper, you have an illustration from the successful application for a patent on exercising a cat with a laser pointer.
Yes, I wanted to be on your show today to admit that I have violated this patent.
I suspect all of us with cats or laser pointers have done this. So that, this is clearly something has gone well off the rails when that happens. Now, other patents, or at least the processes that are patented, are useful after the patent expires. So talk a little bit about that in the context of pharmaceuticals, because this is a place where drug makers make a very strong case that they need that monopoly on profits, on revenue, in order to pay for or incentivize them to bring new drugs to market.
So our report is in favor of patents, but we want to go back to kind of constitutional principles, reserving them for when it's really necessary. And pharmaceuticals are a pretty strong argument for when they are necessary. And the reason is because it costs several $100 million or up to $1 billion to bring a product to market, a pharmaceutical, a long time to get it through FDA testing. And there's a lot of things that can be done there along the way, but if it costs about $1 billion to get the drug to market, the economic data seems to indicate that if they didn't have a period to recoup that investment through something like a patent, then they may not do so. So pharmaceuticals are a very good example of where patents are, in my opinion, rightfully granted.
Right.
Not the least of which because I'm not going to accidentally violate somebody's patents. I can actually look up in a directory and say, hey, this actual formula has already been patented, and so we all know.
People talk a lot about patent trolls, particularly in software situations. How does that affect, and what has happened recently to kind of rein in patent trolls a little bit, but clearly not enough?
So patent trolls are effectively where you have a person or an entity, and they usually are sitting on several legitimate patents or a whole bunch of them, and they go out in the market and they find a startup or usually it's a smaller company that's doing something that they consider to be a little bit similar, and then they usually send them a demand letter knowing that it will cost about $4 million to bring their product to market.
Right.
And so they ask for $50,000. So they're asking for an amount of money substantially cheaper than bringing their product to market.
Right.
And they're able to use usually these very low quality patents that should never have been granted to begin with to shake down these companies when they usually had no intention of actually bringing that patent to market.
Yeah. So talk a little bit though about, you talk about pharmaceuticals, and it's like, yeah, if it costs you $1 billion to bring a drug to market, you're going to want some assurance to get investors to say, hey, don't worry, we're going to have, we're going to get all the money generated by this for 20 years or the rest of the term. But then there are also industries where there are no intellectual property guarantees at all that are very innovative. What are some of those, and what's going on with that?
Oh, sure. So you look at the fashion industry, which is just thriving in the United States, and we've chosen the United States to not allow for any form of intellectual property protection. And when the fashion industry tried to create their own cartel to create a de facto IP protection, that was struck down by the US Supreme Court. But in France and other countries that have a rich history of fashion, they've gone the other way. And actually, you've seen a lot of that, shift to the United States, and so we have a thriving fashion sector without IP.
Right, and something in, I guess, cuisine or menus.
Oh, sure.
That happens all the time, right?
And same with, football plays. Whenever a football team comes up with a new play, other football teams, copy it. And database protection is another example, which is in the United States, a database can't receive a patent protection or a copyright protection, but in Europe they can. Yeah. And what's actually happened is the database market has actually shifted to the United States.
There's a, in copyright, it's probably because in copyright, the term of the copyright keeps getting extended whenever Mickey Mouse is about to go in the public domain, or a couple of other major kind of entertainment powers can muscle Congress to do their bidding. Has that same type of thing been happening in patent, or has it been more constrained, and if so, why?
It's a good question. And patent started off at 14 years, just like copyright, whereas copyright has gone to 135 years. Patents has only gone to 20 years. And so it stayed relatively similar to the prescriptions of the founding era, except for what it's being granted for. The founding era would only be granted for inventions. They would have never believed that you could patent a design.
Right, or a business practice.
Or a business
right?
method,
yeah,
yes.
Which
is particularly pernicious if you think about it, because that's how the free market really operates. Is McDonald's has the idea of coming up with a fast food burger joint, and then Wendy's comes along and all these other companies. And that's what competition is.
Do we throw out hundreds of thousands of useless patents, or do we just stop issuing dumb new patents, or what? Talk a little bit about what has to happen in the reform process.
So in the 90s, they were giving out patents like crazy for software, and then they started to kind of rein that back in, realizing that this is really bad in the software context, because oftentimes there's only one way to do something in the software world. And so that started to be corrected by the courts, but there's a lot more work to be done. But the good news is that these things expire. So if Congress acts today, a lot of these kind of bad patents already in the books begin to expire relatively quickly.
What are your basic reforms? So one would be kind of really changing the ease with which patents get issued. What are the other necessary reforms?
Yeah, first of all, you want these things to be granted quickly, which is that if we want patents, you probably want patents that come to you in quicker than 2 years. You can't wait 2 years to find out if you have a patent or not. But the second one is, it used to be that you had to really teach the world what your invention was. But today, I've never met an engineer in my life who says, when I want to learn how to do this, I look up the patent filing. They're deliberately written to be opaque.
So you're saying in the 19th century, when you're talking about an invention, you could go look at, the cotton gin patent thing, and you could figure out how to build it from that.
Yes.
Yeah.
And so that's actually in the law already.
Right.
The law says that it has to be, readable and explanatory. All we have to do is enforce that law. But it may need to be strengthened by Congress because they're not following it.
Right, and this goes to your earlier point about patents and copyrights are government-granted monopolies, or government-granted rights, and they're not natural rights that come to us from God or the Creator, but rather the idea is that they advance the practical and useful arts or whatever. That they
the progress of the sciences and useful arts.
Yeah, so that they should be useful. Yes. In some way, as opposed to a way of dodging people figuring out how you're doing your business.
Exactly. Yeah. And one interesting thing is when the founders were considering this language in the Constitution, Madison actually had a whole host of other things he wanted to add that he thought also could lead to the promotion of the sciences and useful arts, things like allowing for universities or and that was the context that they were talking about. It was just so important that this instrument of regulatory power had to push science forward.
Right. You're talking about this in the context of economic liberty, because things like copyright, certainly patent, is a restriction on economic liberty. So there's a cost benefit the government is supposed to be making to say, okay, yeah, the costs here to economic liberty will be outweighed by the benefits. How do you or how does Lincoln Labs kind of conceive about economic liberty as a fundamental right or a fundamental aspect of the American experience?
Sure. So I actually believe economic liberty is a natural right. I don't think that copyrights or patents are, but the founders are very clear. If you have an idea or a business, you should be able to bring that to market, and you're not guaranteed success, but you're going to succeed or fail on the merits of how that performs in the marketplace. And so,
so the default is that we should have maximum economic liberty, and then the government or whatever authority really has to make a very strong case to say, except in this area, in this small narrow.
And that's what the founders intended, both in the the privileges and immunities clause and the privileges or immunities clause. There were several provisions of the Constitution where the founders really tried to protect this right.
Do you find that the kind of appeal, or I mean, I think it really fleshes out the context of why we have IP and whatnot. But the appeals to the founders, or the does that resonate with people in contemporary business settings, or are they kind of like, look, that's what the Constitution is like over 20 years old. It's like in a totally different world.
Well, I think it should resonate with them because what we're talking about here is really basic free market principles. And the interesting thing about the regulation stuff is conservatives and libertarians often have a lot of trouble with this mounting level of regulation. But at least with regulations, the agency's supposed to look at pros and cons. We may disagree with their conclusions. But what we see is that the patents being granted are 10, 20, 30 times more page length than the regulations. And there's no pro and cons being weighed. And they're being given out every single year kind of willy-nilly. And it's really the regulatory stake run amok.
We're in an age now, which I think is one of the benefits of the financial crisis, is that there's a really kind of transpartisan interest in crony capitalism and rooting it out. And this, you make a strong case in the paper that it is big companies, powerful companies are often trolls, they're cronies. Explain how that works.
Well, basically what I want is I want a market where there are very low barriers to entry for new market participants, because I believe that's where innovation comes from. Joseph Schumpeter has this whole theory called creative destruction, which is new guys come in and old guys either adapt or die. And oftentimes you have a lot of these incumbents that really patent obvious things that stifle that process. So I'll give you an example. Let's say you and I decide to go into business. My idea is a cell phone that uses Wi-Fi to keep recharging the battery. Now this is technically possible. And so it would be a cell phone that never turns off. And so we're working on this idea. We're about to bring it to market, launch a Kickstarter. All of a sudden you give me a call and you say, hey, that cell phone we're working on, it has rounded rectangles, doesn't it? Well, Apple has a patent on that. We're going to get sued. And I say, oh, this is ridiculous. Okay, so we scrap that plan. Let's go back to the drawing board. Well, let's look up how many patents apply to smartphones, so that way we really don't infringe anybody's patent. And you call me up and you say, well, it's about 300 to 400,000 patents that apply to smartphones. I say, well, how much does a patent lawyer cost? That gives you an example of what it's like for an innovator today. That's one reason why we haven't had new startups offering new smartphones in the market. And we want most markets to be such that anybody can bring an idea like that. They're not guaranteed to succeed, but they lose because the consumer doesn't like their product, not because of this thicket of patents.
And patents are, you can buy and sell them. Yes. So if you're a big company, you can buy up a lot of patents and hang on to them and then kind of trot them out when you think you might be able to use that to crush competition.
Yes. And with the smartphone market in particular, actually what we're seeing is you have Samsung and Apple and a few other companies, and they're basically all infringing on each other's patents.
Right.
And they have this, mutually assured destruction policy. I won't sue you if you don't sue me, for the most part, until it goes, belly up.
So it's a cartel, effectively, among a few producers who, the one thing that they all agree on is to keep out little guys who might actually come up with something truly innovative and transformative.
Yes, and that's the worst of all worlds, is that, that may work for Apple and it may work for Samsung, but if you and I have this new idea for a cell phone, Apple's probably not going to license it to us unless they don't think we're a threat. And that's, you don't want to have to ask permission from the incumbent in order to innovate.
Right. Well, we will leave it there. The paper is How to Fix Patents. Economic Liberty Requires Patent Reform. The author is Derek Khanna. It's out from Lincoln Labs. Derek, thanks for talking to us.
Thanks for having me on.
For Reason TV, I'm Nick Gillespie.